Breaking news out of California. The state of California, in the case of Duncan versus Bonta, dealing with the so-called large capacity magazine ban in that state, has filed their major submission explaining why, in their view, the Second Amendment allows them to ban large capacity magazines in the state of California under the Second Amendment and NYSERDA versus Bruin. Well, I think that despite excellent lawyering by the state of California, their arguments are dead on arrival. Let me tell you why when we get back. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gunner and constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxer Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers as fast as possible to help us with the social media algorithms. Okay folks, I have breaking news here. I have in my hand the brief submitted by the state of California justifying why they think their so-called large capacity magazine ban, which as you know is just standard capacity magazines that hold more than 10 rounds, why they think that their ban is constitutional under the Second Amendment and NYSERDA versus Bruin and Heller. I am going to try to take out all the major arguments of California on their large capacity magazine ban. I'm going to try to do it simply by reviewing a single piece of paper, which is their table of contents of their brief. That's right. I'm simply going to go through their table of contents of their brief, and I'm going to point out why everything they say in the table of contents is clearly wrong under the law and why we should win. I will in time deal with the other over 200 pages of what they've submitted and point out their flaws as well. But I, for this purpose of this video alone, will just take on the table of contents and show you why their arguments, in my view, are dead on arrival. Let me start with the beginning. To start with, the name of this case, as you know, is Duncan versus Bonta. It deals with the so-called large capacity magazine ban in California. The state of California has some excellent lawyers. I thought that the quality of the lawyering here, the quality of the arguments here, I thought the quality of the writing here was strong. I thought it was good lawyering. But the reality is the lawyers in California have been tasked with what I consider to be almost an impossible task, which is to justify under American law and the Second Amendment, the ability and authority of a government to ban arms such as magazines and so-called assault rifles. So I just want to be clear about that. I'm taking on these arguments specifically, and their arguments, in my view, totally come up short and will not be able to justify banning so-called large capacity magazines, which again are standard capacity magazines that hold more than 10 rounds. The first argument they make is that the large capacity magazine ban, quote, does not burden conduct covered by the plain text of the Second Amendment. What have I taught you? I've explained to you repeatedly that the anti-gun argument will be they're going to desperately try to avoid having to justify their gun control laws using historical analogs because there really aren't any powerful historical analog gun control laws in 1791 at the time the Second Amendment was adopted. So what the anti-gunners are going to do, and I told you this and you know this, they're going to desperately try to avoid having the burden of proof shifted to them. And the way they're going to do that is to try to have the fight about everything involving the Second Amendment at the first stage of the discussion, which is what does the plain text of the Second Amendment mean? And that's exactly what California is doing here. Just as predicted, the first argument is that these magazines do not burden conduct covered by the, quote, plain text of the Second Amendment. And why not? Because they say that the right of the people to keep and bear arms does not include magazines, because magazines are not guns. Bing bong, bing bong. Come on, let's go. We know that's absurd, right? Let's start from the top. Number one, arms covers all things that can be used offensively and defensively. We've talked about this. The U.S. Supreme Court said, for example, that handguns are protected arms in the Heller case. In Caetano, the invention from the 1970s, stun guns can be used offensively and defensively, even though they were invented in the 1970s. Those are commonly protected arms. And remember also in Caetano, the concurrence by Justice Alito, what does he talk about? Well, he talks specifically about how semi-automatic pistols are protected under the Heller case from 2008. And why is that important? Well, for those of you who know anything at all about firearms, if you're talking about modern firearms, which we are here, because the Heller decision by the Supreme Court specifically said, as did Caetano, that modern firearm technology are protected under the Second Amendment. Because just in the same way that modern forms of communications like the internet and telephones and the radios are protected by the First Amendment, so too are modern firearms protected by the Second Amendment. That's been said repeatedly. Even Ruth Bader Ginsburg agreed with that statement, by the way. So the point being is this, that we know that modern firearm technology is protected under the Second Amendment. The Supreme Court has said it not only in Heller, but also in Caetano. And guess what? What are they talking about when they talk about modern firearm technology? Semi-automatic weapons. And semi-automatic weapons, unless they're only going to be a single-shot revolver or a single-shot firearm, guess what? Require either a fixed or a detachable magazine, right? You can't have a semi-automatic firearm work without a magazine, whether it be fixed or detachable. But either way, it's a magazine, because if you don't have a magazine, the gun will not fire at all, or if it does fire, it will fire one round. And we know that single-shot firearms are not the only things protected, because the Supreme Court says modern firearms are protected, which by definition means firearms that shoot more than one round, unlike, let's say, dueling pistols in 1791. So a single-shot firearm is not enough. They can't limit us to one round, right, under the Second Amendment. So that's what they're trying to do here. So they're saying that, again, magazines are not arms because they're not guns, but it doesn't matter. Let's look at the case law. Remember that anything that helps a firearm function as a firearm, bullets. Well, bullets are not guns, they're bullets. But obviously there's been multiple cases that say bullets are protected by the Second Amendment. In fact, you know who actually said that bullets are protected by the Second Amendment even though they're not guns? Is the Ninth Circuit Court of Appeals. That's right, the Ninth Circuit Court of Appeals, which is binding precedent on Judge Benitez in this case of Duncan versus Bonta, has already said that bullets are protected arms under the Second Amendment because you need bullets in order for the arms to function for their intended purpose of being firearms, of shooting projectiles. Well, guess what? Magazines are just like bullets. They're obviously arms because they're essential components of firearms, especially modern firearms, which have been undeniably explicitly protected by the Second Amendment. So obviously, and several cases have cited and quoted and discussed how magazines are protected arms. And I'm going to get to that in just 1 second. Something California, I think, was playing a little bit of game here with the court. We'll get to that in 1 second. Okay, that's the first thing they say. Let's continue on down the table of contents. Then they go on to say, bing, 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 bing. You're going to know this. They say that large capacity magazines are not protected arms because, bing, bing, bing. Listen carefully. You've heard this before. Ready? Because they are not commonly used for self-defense. Oh, surprise, surprise. We talked about this on the channel. Why isn't California watching this channel and learning about the Second Amendment? That's right. They're arguing that the legal standard is that the Second Amendment plaintiffs have to demonstrate that magazines that hold more than 10 rounds are, quote, commonly used for self-defense. Absolutely not. No, absolutely not. That's clearly not what the case law says. First of all, the Heller case, which is binding on, remember, if it's a arms ban case, if they are banning the possession of any kind of arm, as opposed to regulating it, we'll get to that in a second, if they're banning the possession of an arm, it falls under the Heller test. The Heller test, as you know, and Caetano as well, is the, quote, in common use test. And what does in common use means? It means that if a modern-day firearm is in common use by Americans for lawful purposes, it is a protected arm under the Second Amendment. It may not be banned. Period. Full stop. That's what Heller says. That's what Caetano says. That is basic black letter law. Now, you see the little game here. Now, I told you about this weeks ago. This is the game they're going to play, and surprise, surprise, California is playing this game as predicted. But don't worry, because we know the answer right off the top of our heads, don't we, folks? And that is this, that if you look at the Heller case, it talks about in common use for all lawful purposes, such as self-defense. And that's a key word. The words in Heller are such as self-defense. The words such as mean for example. Okay? So all lawful purposes such as self-defense means all lawful purposes including but not limited to self-defense. And mind you, don't trust me. Take a look at what Supreme Court Justice John Paul Stevens said in the dissent in Heller. Signed on by all the dissenters, and there were 4 dissenters. They all pointed out in their dissent in Heller that the standard that the U.S. Supreme Court was adopting in common use was for all lawful purposes, including hunting and recreation, in addition to self-defense. But you see what California is doing here is they're trying to say, no. You have to show that these are commonly used for self-defense, but that's not the law. That's not what the Supreme Court says, and they should know this if they just read the cases and the Stevens dissent, that it's in common use for any and all lawful purposes, including but not limited to self-defense. But you see right here in the table of contents, they're trying to play that game right off the top, but again, I don't think it's going to work because that is simply not the law. But let me carry on. Then California also ball drops this, and this is another little game they're playing. Remember, we've talked about this before. If you are banning an arm, and when you ban a magazine that holds more than 10 rounds, you are banning a type of weapon. You are banning a type of arm. In that case, magazines that hold more than 10 rounds. That is a ban. That is not a restriction. That is not a regulation. It is a ban. You are banning magazines that hold more than 10 rounds, which is no different than banning all handguns by the District of Columbia in the Heller case in 2008. So when you are banning an arm, which this is, you apply the in common use test, which is if it's in common use for lawful purposes, it cannot be banned. Now, with that in mind, let's take a look at argument number 2. I'm only on the table of contents here, by the way. You wait till you hear what I have to say about the rest of the brief, which we'll get to in other videos. I'm only dealing with the table of contents to show you how I can defeat the anti-gun arguments just from their table of contents alone. That's right. Argument number 2. In their table of contents, they say that the large capacity magazine ban is consistent, quote, consistent with the nation's traditions of weapons regulation. Oh, hear what I just said? Quote, weapons regulation, close quote. What's the problem with that? Again, we're not talking about regulations. We're talking about an outright ban. So you can have 1,000 historical analogs that say, see, we can regulate guns 6 ways to Sunday, which, by the way, they don't and they can't. But set that issue aside. Let's assume, arguendo, that they have 1,000 examples of regulations on firearms. It doesn't matter for 2 reasons. First of all, the regulations don't matter because the Supreme Court has already looked at all the historical analogs dealing with gun ban or arm ban cases in the 1791. That's what the work they did in Heller, right? The Supreme Court has already done the work. They looked at all the historical analogs, the history, the tradition, the text involving gun bans in America in the Heller case, which was a gun ban, that was a handgun ban case, and they came up with the in common use test. Again, if it's in common use, it can't be banned. So here, all the court has to do, Judge Benitez has to do, is simply apply that standard. Doesn't have to look at anything else. So here, what the court, so number one is the state of California is trying to argue that you look at historical analogs, but you don't, not when it's a gun ban case or an arms ban case. But number 2, the other problem with this is we're not talking about a weapons regulation. They are banning an arm. They are banning large capacity magazines. That is a gun ban. It is not a regulation. Okay, let's carry on to the next point of the table of contents alone. Their table of contents says that the large capacity magazine ban law goes on to say, quote, it involves a, quote, dramatic technological change from the firearms technologies widely available during the founding and Reconstruction eras. I repeat, this is California's law. Quote, the large capacity magazine gun ban, quote, represents a dramatic technological change from the firearms technologies widely available during the founding and the Reconstruction eras, period, close quote. That's their quote. Again, come on, really? Come on. First of all, we know that having firearms that can fire more than 1 round existed in the founding era. We know at a minimum, I'm not even going to get into the other examples here, just at a minimum, the Girandoni air rifle that Lewis and Clark brought at the behest of Thomas Jefferson as President of the United States. Thomas Jefferson, the author of the Declaration of Independence, as President of the United States, sent Lewis and Clark out west to explore the western territories that we had bought pursuant to the Louisiana Purchase from Napoleon Bonaparte. Right? And what did they bring? They brought a Girandoni air rifle. There was an Austrian gun, I believe, and it had between 20 and 24 rounds. And here we have California in their table of contents alone talk about this as a dramatic technological change from the Revolution. First of all, it's not even true. It's not even true to begin with, number 1. Number 2, it doesn't even matter. Hello? How many times do we have to go through this? It's not even me. It's the Supreme Court. Right? The Heller case and Caetano case both specifically said that modern firearms technology is protected if it's in common use. It doesn't matter if that technology existed at the time of our founding. It specifically says that repeatedly. The Supreme Court has said this not just with the Second Amendment, but with all the other amendments. And here's California saying that these magazines, these firearms that fire multiple rounds without reloading, these are dramatic technological changes. It doesn't matter, and that's not even true, right? We know that. So there you go. I would say, and of course, they're trying to talk about the Reconstruction eras, which, as you know, is way too late in time. The only era is the 1791 era when you look for the original public meaning of the Second Amendment. And one last point I want to point out, if you look at Article 1 of the United States Constitution, one of the powers Congress has is the power to create a patent and useful arts monopoly or office to encourage people to engage in patents. Well, why did our founding fathers, many of whom were inventors themselves, like Benjamin Franklin and Thomas Jefferson, were both prolific inventors, why did they put in the Constitution itself, even before we adopted the Second Amendment, because the Constitution came first, the Second Amendment and Bill of Rights came 2 years after it, or a few years after that. Why did they do that? Because the founding fathers knew that technology was going to continue to improve because they were actually inventors themselves, including Franklin and Jefferson. And in Article 1 of the U.S. Constitution itself contemplates technological advances in all things, which obviously would include firearm technology, which we know the founders were very interested in for making sure there was a firearm capacity and firearm production and so on to protect the new country against European invaders. Now, let me continue on to the next point California makes. In the table of contents alone, trust me, we're going to get to the rest of this brief in future videos. I'm just going to do the table of contents today, just to show you how much I know we can win this case. Next one talks about how the large capacity ban, quote, addresses the unprecedented social problem of mass shootings. The unprecedented social problem of mass shootings. Again, California is clearly just wrong historically. Okay, first of all, notwithstanding the fact that this is not relevant, the reason why this is not relevant is because the United States Supreme Court in Heller, with Justice Scalia's opinion, specifically said at the end that balancing tests of the good of gun ownership and the bad of gun ownership in America is irrelevant to courts. It is not a question for the Second Amendment anymore, that the founding fathers already engaged in that social balancing test, and it's not allowed by anyone in government, not least including the courts themselves. That is what Justice Scalia wrote in 2008 in the Heller case. And as you know, in Bruin, they reiterated this concept that says no more balancing test. Courts, we are telling you repeatedly, you have to do text and history, no more balancing test. And here you have them trying to argue about unprecedented social problems of mass shootings, which I would argue, again, is some form of a balancing test. But beyond that, it's not even true, because just at the most basic level, we have the Boston Massacre, I believe in 1770, where you had, I think, 11 people were shot by the Brits. 11 Americans were shot by the Brits, 5 of whom were killed. That is a mass shooting in 1770. So you don't tell me the founding fathers weren't aware of mass shootings. That was a mass shooting that helped kick off the American Revolution. And go beyond that. We've talked about this in other videos. The countless different attacks, of which dozens and dozens of people, men, women, and children, were murdered by attacks by either the Tories, by British soldiers, or by Indians, and so on and so on and so on. So clearly, the quote-unquote unprecedented social problem of mass shootings that the founding father, that the anti-gunners want to talk about here in this California brief is the same problem that the founding fathers faced, which is really just a form of mass killings, mass attacks, trying to keep people alive. And what did the founding fathers do in response to those mass attacks and threats? They actually did not have gun control. They encouraged gun ownership. The best example of this in my mind is look at churches. At the time of the founding, when everyone in a community got together at a church, they congregated together as a group. They were sitting targets, right? Everybody who was bad in the area, anyone that wanted to kill the community, knew exactly where they would be on Sunday morning. They would be in that church at that place. They would all be there together, praising the Lord and so on and so on. So and guess what the founding fathers did when the whole community came together to pray to God and congregate? Did they have a gun-free zone sign in the front of the church? No way. They did just the reverse. They actually told you need to bring guns to church to protect against bad people. So as the Supreme Court said in Bruin, that where there's some sort of social issue that is similar to what we're facing today, and if the founding fathers did not use gun control to deal with that particular social issue at the time of the founding, you cannot use gun control today to deal with that same issue. And again, mass shootings is really just a reference to murder by criminals of innocent people. Nothing unusual about that. It's terrible. It is rare, of course. But again, the problem of human-on-human violence is not new. It goes all the way back to Cain and Abel. Again, the founding fathers were well aware of human violence. They dealt with they just fought an American Revolution with a lot of violence and a lot of gunplay and a lot of killing going on. They were not naive when it came to human-on-human mass killings and mass shootings and so on, because they lived it, and that's pretty clear. And nevertheless, we know that modern firearms are protected arms because the Supreme Court has said that repeatedly. I just want to mention in their last point, and again, we're going to talk about the rest of the brief in future videos, but in their last point here, they have basically summarized it the following way, quote, California's restrictions on large capacity magazines are consistent with the historical laws regulating other dangerous weapons, period, close quote. So you see, California's playing a game here, but it can't work. They're using the word restrictions, and then they use the word regulating. What's the problem with restrictions and regulating? The ban on magazines is a ban on arms. It is not a regulation. It is not a restriction. It is a ban. But you see how they're trying to play this game here. They're trying to talk about, hey, look at these regulations and restrictions on various kinds of guns. Wrong legal standard. It's the in common use standard that applies, not all this other stuff. By the way, keep in mind that and remember, the in common use test is justified historically by the Supreme Court by looking at the historic laws in 1791, including a reference in Blackstone to the potential to preventing people from carrying dangerous and unusual weapons. Blackstone actually said dangerous or unusual weapons, but the American commentators interpret that as dangerous and unusual weapons, which is also how the Supreme Court interprets it. And of course, that in common use test, if a weapon is in common use, it by definition cannot be dangerous and unusual. But as you see here, California is trying to play this game about, hey, you got all these examples of regulating other dangerous weapons. But again, this is not about regulating weapons. This is about banning weapons. And last but not least, keep in mind that in addition to the fact, another conceptual way to think about these bans on magazines is they're also banning a type of firearm themselves. Because if you ban magazines that hold more than 10 rounds, what have you done? Think about it for just 1 second. If you ban magazines that hold more than 10 rounds, what have you done? And what you have done is you have banned firearms, an entire class of firearms that are capable of shooting more than 10 rounds without reloading, if you ban the magazines that go into them as essential components. So you actually do have, as I would argue, in California, a firearm ban with these magazine bans, because again, without magazines that hold more than 10 rounds, you have effectively banned firearms that can shoot more than 10 rounds without reloading. And therefore, even if you want to argue this needs to be a firearm ban and not just a magazine ban, I think you actually do have a firearm ban of a class of firearms, i.e. firearms that can shoot more than 10 rounds without reloading if you get rid of these magazines. But okay, all right, folks, I know this is a little bit longer video, a little bit geeky. All I did is I literally just went through the table of contents alone of California's brief. We're going to do a lot more than that, I can assure you of this. But I think just based on the table of contents of California's brief, I've done a pretty good job of taking out their entire argument right here and right now in under 20 minutes or so. Okay, folks, hope you learned a little bit something. Stay tuned to the Four Boxes Diner. We're going to be doing a lot more about California and other states to teach all of you how you apply the Second Amendment all across America in all types of cases and all types of issues. And again, if you haven't subscribed, please do so. We really would appreciate it. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.